quorum again, but I would like for everyone to just turn on your cameras so that we can see that you're here and still looking good. And then that'll be our attendance, and then you can turn off. Okay, I don't know if I saw Jennifer, Laredo, or Diane yet. Are you guys here?
I'm here.
There's Diane. And Jennifer, are you here? There you are. Okay. You're still looking great, all of you. I inhaled my lunch in about 5 minutes. So if I become a little dyspeptic during this part of the meeting, I apologize. And also, I think Dr. Bradbury cursed us by saying, we only have just regulations to go through. Because what I mean by that is I would like to reopen agenda item number 6, and that's the Access to Veterinary Care Committee report. When I had a discussion with Dr. Nolan before this meeting, and she proposed that moving forward, she would like for the board to participate on the committee that is formed by the CVMA. I made the assumption that they were going to have a stakeholder meeting. And so I thought that that was a good way to go so things wouldn't be duplicated. When Dr. Miller made the presentation on what the intent of the committee was and who was allowed to participate, then that would not actually be a stakeholder meeting. It would just be a meeting of CVMA members, which is in their bylaws, and it's totally understandable. But we, as an advocate for the consumer, I think it's going to be important for us to have our own stakeholder meeting so that everyone, including people who are not CVMA members, can be given the opportunity to give their input on how to address this on this issue. So does that make sense to everyone? So the way that I would envision it is that our subcommittee is still made up of Dr. Nolan and Diane Prado. The idea would be for them to hold a stakeholder meeting. If any of you recall the last stakeholder meeting we had, it was on the issue of physical therapy. And the way that was conducted was that we invited stakeholders, people who we know and are familiar with and have a vested interest in this, and then hold a stakeholder meeting that would be open to the public. It would be noticed, it would be agendized, it would be webcasted, so that anyone who we did not invite definitely could participate through the Q&A sessions. I think that we would have to have it sooner rather than later. So it would have to be a WebEx meeting, not an in-person meeting. And I think that that just would be the right thing to do. Does Dr. Nolan have any comments, or Diane?
Thank you, Mark. I really agree with you. I did misunderstand the scope of the CVMA's task force, and I am very excited about being a part of it, but I do agree that we need to press forward as well. So I'm looking forward to working with Diane right away and getting something put together.
Diane?
And I'll just second. I'm looking forward to working with Jimmy as well, and this is exciting. So thank you.
Mark, do you need a motion or no?
This, I'm not sure. Basically, what we're doing is directing the subcommittee to hold a stakeholder meeting. So does that need a motion, Jessica?
I don't think so. I think when the Access Committee was created, that was the intent, was to have these stakeholder meetings. So I think it's just really to continue with the Access to Veterinary Care Committee and the original intent of it.
Okay. And then when a stakeholder meeting is held, as far as who can call in, there won't, with the two members on that subcommittee, those two members will be participating in the stakeholder panel. Is that correct?
For the board's Access to Veterinary Care Committee, is that what you're
Yeah.
talking about? Yeah.
Yeah, so Dr. Nolan will be leading that stakeholder meeting. Will Dan be participating in that meeting as well?
Yes, that would be the intent, is that she would participate as well as a member of the committee.
And just as in MDC meetings, any board member can certainly log in and watch it, but we are encouraged not to participate in it. And those rules would apply to the stakeholder meetings, correct?
That is correct.
Okay. Does any board member have any questions about that or comments? And okay, should we open it up to the public?
Yeah, I would recommend doing so just in case, because we did clarify the direction of the Access Committee, which is slightly different than what it was before.
Okay. And to the CVMA, I definitely appreciate all the input that you've put into various issues, and I completely understand the restrictions that you have with your bylaws.
And this is the moderator. I've opened the Q&A panel. If you'd like to make a comment, please click on the Q&A icon on your screen, type comment into the text box, and submit that to all panelists.
Did our audience come back from lunch? Can we?
I think so. They're all still connected.
Okay. All right.
Not seeing any requests. You want me to close the panel?
Maybe let's give it 15 more seconds,
Okay.
just in case they inhale their lunch as well.
Right.
And then we can close it.
Still not seeing any requests, and I'm not seeing any hands with waving waving because they're having trouble.
Okay. All right. If then we can close it. If there's anyone that we missed, then they can always send us an email. And then now we can move on to agenda item 9A.
Okay, thank you. And that'll be me, Justin Sotelo. Moderator, could I please share my screen?
Absolutely.
Thank you.
You now have control.
Okay. And everybody can see that, I presume?
Yes.
Okay, thank you. Okay, so this is just our general status update on pending regulations. As noted here in the memo, we do have 15 rulemaking packages that are currently pending in the process. 4 of those packages are currently in various stages of the initial or final phase of the review process, as identified below and in the attachment. The remaining 11 packages, which includes 2 Section 100 rulemaking packages, are also pending preparation by board staff in order to move forward. So the purpose of this memo, again, is to provide you with an update, a status update since our last board meeting, which was held in October. And we have I believe, 4 or 5 items listed here in the memo. The first one is our fee schedule certificate of compliance package. And as many of you recall, this was in response to our emergency filing that raised fees associated with veterinarian and university licensure and RVTs. It also added a new fee associated with the approval of schools and institutions offering a curriculum for training RVTs. So the emergency filing was initiated last January. Since then, we also had to do a readoption of the filing. But subsequently, we're also required to do a regular rulemaking package in order to make the fee change permanent. So that is the certificate of compliance. You'll see here that it was approved by the Office of Administrative Law approved on June 1st. So those fee changes became effective on June 1st upon filing with the Secretary of State. So this package has been completed, and we can check this one off the list. And I'll just ask if there are any questions about a specific package, just feel free to chime in. Otherwise, I'll move on to the next one. Okay. So the next package listed here is for animal physical rehabilitation. And again, as many of you know, this has been an issue discussed by the board for quite some time. I'm happy to say that we're at the end of the process. On June 9th, we submitted the final rulemaking file to the Office of Administrative Law. OAL is currently reviewing the file. The reviewing attorney has, however, informed us that this package will require a final vote or adoption by the board. So we plan to bring this back to the board in October in order to obtain that final vote. And we're still within our deadline, within the deadline. So we should be fine. We have a deadline of, I believe, mid-November in order for OAL to complete their review. So that is the status of that package. Any questions with that one? Okay. The next one listed here is drug compounding. And I won't go into great detail because this item is also on the agenda item 9C, and our regulatory counsel, Karen Halbo, will be presenting that item. But just in short, again, we're nearing the finish line with this one as well, and we had submitted the final package to DCA for final review. It goes through DCA and agency a final time before it's submitted to OAL. But in submitting it to the regulations unit, there were some questions that came up through the review process. And again, Karen will summarize those issues and concerns. We will be, in order to address those issues, we're going to make some modifications, or we have proposed modifications for your consideration. If approved by you today, we will have to notice that for another 15 days. And then providing no adverse comments are received, we can then proceed with moving the final package forward. Okay, the next one listed here is disciplinary guidelines. This is another one that is on our agenda today, item 9B. And again, we've gone through the initial comment period, the 45-day comment period. We, as staff, noticed that there were some additional modifications that we wanted to include in the guidelines. So we subsequently put it out for public notice again for 15 days. In doing so, we did receive one comment from Ms. Bonnie Lutz with some recommendations, some additional revisions to the document. So those are before you today in the next agenda item. So we've gone through the initial public comment period. We did a 15-day comment period to address modifications. This would be considered a second modification. So again, we would be required to notice this for another 15 days upon your approval today. So again, I'll go over that in more detail in the next item. And then the final item listed here is just the last package that was approved by the board in April. It is a Section 100 proposal that would make a non-substantive update to the regulation, Section 2039, as a result of a merger of the associations listed here in the summary. So just a minor non-substantive change. And then we also include just the overall status spreadsheet here, providing you with any updates since the last meeting. Any updates since April are provided in red text. So, and if the step in the process is completed, it is shown with a green highlighted cell. Anything pending is in the gold color. And as Jessica alluded to a little bit earlier, we still do have a number of regs in our queue. It is my hope that once we get the APR, disciplinary guidelines, drug compounding finished and through the process, we will then be able to shift gears and really focus on the next set of packages that are in our queue. So that concludes my update, unless there are any specific questions.
Thank you, Justin, for providing that colorful chart. It's very understandable, and it was something that the legislatures asked for during our sunset hearing, and I was very proud to realize that we already do it. They didn't need to ask us to do it, and also thank you for giving a brief introduction to the regulations you're talking about, because a lot of these we talked about even years ago. So sometimes it's hard to remember which regulations you're referring to, but thank you for that.
Okay, thank you. Okay, if there are no additional comments, I can move on to agenda item 9B. Give me just one moment here. Okay, so as I mentioned, this package required another modification to the text. The modifications were noticed in May for 15 days. During that time, we received one comment or written comment from Ms. Bonnie Lutz, and that is provided as attachment 1. And then I'll kind of briefly go over her recommendations here on the next page. So we broke it down into, there were essentially 4 recommendations. The first one noted here had to do with the language in the introduction. And I'll just read it here briefly. In the introduction of the disciplinary guidelines, Ms. Lutz requests that the last sentence of the last paragraph be revised to read, the board may consider sending copies of written communications sent to respondent's private counsel if respondent requests that copies be sent and identifies the name and contact information for private counsel. However, the respondent must continue to communicate directly with the board staff, notwithstanding the involvement of private counsel. Ms. Lutz states that this revision would allow a respondent's private counsel to be informed as to what is happening as far as a respondent's compliance with the terms and any possible misconceptions or miscommunications. So in response to that, here's the proposed response for your consideration. The board sends communications directly to the respondent, and it is the respondent's responsibility to inform their private counsel, requiring the board when requested to also send copies of board communications to private counsel imposes additional tracking and mailing workload on staff and unnecessary cost to the board. During proceedings, a respondent may change attorneys by hiring a new private counsel and not notifying the board. This could require even more burdensome tracking and mailing of duplicate copies of written communications by board staff. Accordingly, the board is rejecting the request to add or revise language in the introduction of the disciplinary guidelines regarding the distribution of written communications to respondents' private counsel. So that is the proposed response for your consideration. For item number 2, it was a similar suggestion or recommendation, and for the same reasons noted above, we are also rejecting that recommendation. For item number 3 here, there was just a request for clarification under optional terms number 6 and number 7. Ms. Lutz states that these sections appear to separate direct and indirect supervision. She asks if there is any way to clarify this if the supervisor for direct supervision needs to review records, and if it can be clarified that the terms will include either number 6 or number 7. Additionally, she states that administrative law judges might not understand that these are alternative provisions, leading to the situation where a veterinarian needs to hire 2 supervisors. So for this recommendation, we were agreeing with it, and here's the proposed response. The board agrees that these 2 sections should be clarified to address the questions and concerns raised by Ms. Lutz in her comment. And I'll bring up the actual disciplinary guidelines document here in just a moment, just so you can see where these changes are actually occurring. Her final recommendation, number 4 here, under optional term number 9, no management, Ms. Lutz suggests a revision of respondent shall not manage to read. Respondent shall not function as the responsible licensee manager for any veterinary hospital for the duration of respondent's probation. Responsible licensee manager for the purposes of this section is defined in BNP Code section 4853C. She states that it makes this suggestion in response to numerous veterinarians on probation who question this provision and requests that it be clarified. So again, we are agreeing with the requested clarification, and as I noted, I can show you where that is captured in the actual document. So additionally, so we're proposing to incorporate 2 of her recommendations, but additionally in pulling up the document again, staff found some additional required revisions and some technical cleanup. So we've outlined basically everything we're proposing in this latest round of modifications here on pages 3 and 4 of the memo. The first one is just a simple date update. I think we previously had a January 2021 date, but now we're just modifying the date to reflect this month and year, so July 2021. And I think at this point, I'm going to jump over to the document so I can just show you where all of these other changes are occurring. Is that okay, Dr. Nunez, or do you have any other suggestions in terms of how I go through this?
I think that's fine. When we go to discussing them, I probably will take them individually, but I think it's good just to go ahead and move on to the actual guidelines and show us where those changes will be.
Okay. So with the last modifications that we did to the guidelines, we added a new section in the guidelines entitled medical records review. So in reviewing these again, we noted that for the penalties outlined on pages 3 through 11, that minimum penalty needed to be added. So I'm just going to kind of quickly show you, like, here's the first example. And again, these latest round of modifications are shown in a double blue underline or double red strike through. So here is the first example of where we're adding medical records review as a minimum penalty. And please feel free to comment on where these have been included. These were suggested or reviewed by our probation monitor, by Jessica, and by board counsel as well. But if anyone else feels that medical records review should be added anywhere else on these pages under minimum penalties, please feel free.
Tell us again, what was the criteria you were using to place it there? You said,
Yeah, and I might, Jessica, if you don't mind, because
Sure.
Jessica can probably provide a better explanation than I can.
Sure. So members, as you can recall from the last meeting, we instead of having just one supervision requirement that really mixed up between what supervision meant and the review of the medical records, we broke them up into two separate sections where you have the supervision review, the supervisor requirement, and then you have the medical records review. And so when we go through these, probably how you did it the first time as well, back in the day, was you look at the reasons why they were placed on probation, which is the violations that you see listed in the sections. And so we're looking at what penalties are necessary, what conditions are necessary for consumer protection, and to help demonstrate that the probationer is being rehabilitated. And so if you have, say, for example, a probationer who had a number of medical record specific violations, they might not need a supervisor to provide the physical presence and the supervision over the services being rendered, but you would still want the medical records to be reviewed. And so that's where you would just have the medical record review condition and not the supervisor condition, if that makes sense.
yeah, Jessica, I think also we separated direct versus indirect supervision, whereas the direct supervision was going to be another veterinarian physically there to supervise the probationer as that probationer was practicing, whereas indirect supervision meant medical records review. Is that correct? Is that how the discussion went?
No, not quite, but we can get when he gets to the supervision discussion, that's where we bring up more need for clarification from the board on how they want to define the supervision. So we'll get to that part in a second.
Okay.
Okay, so I'm kind of going back and forth. I'm showing the document, but I'm also referring to the memo, and I'm on page 4, item number 3. So that says that we would strike the optional term and condition of supervised practice from BPC section 4855 on page 10 to correspond with the previous modifications, which revised optional term number 6, supervised practice, and added new optional term number 7, medical records review. So in this instance, we are striking supervised practice and adding medical records review. Okay. Now I'm on item 4 on the memo, and I'm going to jump to page 14 in the document. Okay, so for number 4, we're adding language to the following standard and optional terms found on pages 14 through 24, specifying those terms and conditions that shall not be told. In the memo, we provide an explanation in each instance why that term shall not be told. But for the fourth modification to the document, we're adding language under each item, each term, where we're indicating that that item shall not be told. So I don't know if there are any questions on that, or Jessica, if you wanted to provide any additional information.
I'm happy to answer questions, but I think you did a great job on the memo explaining all of the justification for it.
Yeah. Okay. And that was actually Jessica. But yeah, on pages 4 and 5 in the memo, in each instance, we're providing a specific explanation as to why that term or condition shall not be told. Okay.
Yeah, so this portion is basically saying that going on toll cannot be an opportunity for a probationer to go and binge on something they shouldn't be binging on. You can't go up and break the law and not be held accountable for that. It makes perfect sense to me.
Okay. Okay, so I'm referring to item 5 on page 5 of the memo now, but I have the language pulled up here for you, and I'll just read it. Amend language under standard term number 10, tolling of probation, on page 16 to address the maximum time probation can be tolled before a license is canceled, and the exception to the 2-year limit to tolling of probation for a respondent who is residing in, practicing in, and is on active probation with another state in the U.S. As written, tolling can last indefinitely, even though many probationers in tolling status may never intend to practice in California again. Monitoring probationers in a tolling status requires board resources and should not continue indefinitely. So these modifications are in response to that. So if there are no questions, I'll move on to this item here. Okay, so we're amending the title of standard term 11, and it looks like it jumped up to page 16. It was on page 17. From changing the title from maintain a valid license to maintain a current and active license on page 17 to reflect the correct terminology for the actual license status. So that's what that change does. And Jessica, please remind me here, the strike through that we're doing, was this more of a technical?
Yeah, it was really just for clarification purposes, because when you read the 2 sentences that were there, they kind of contradicted each other. And so the whole goal of this condition was to let them know that they have to maintain a current and active license, period. That's the condition. And so I think that to simplify it is just to say what the requirement is, rather than create these circle conversations of, well, it is required, but then if you don't do it, it's just it just provides an option for them not to comply with it. So it just didn't make much sense. I think for clarification purposes, the requirement is just that they maintain a current and active license.
Okay, thank you. Okay, so now I'm going to jump over to page 16. Sorry, it's going to be bear with me. So the last 3 modifications identified as items 7, 8, and 9 in the memo are in response to Ms. Bonnie Lutz's recommendations. So basically, as I mentioned before, the recommendations that we agree with, or that we are in agreement with, we are making those modifications in the document. So let me get to optional term number 6. I'm sorry, I'm seeing 2 sets of page numbers and it's throwing me off.
Yeah, I understand what you're doing, so don't worry about it. You're
Okay.
doing good.
Okay, thank you. Okay. And there's a note here. There's a decision that we need your assistance with. But let me just read here. For item number 7 in the memo, amend language under optional term number 6. It would be this one, entitled Supervised Practice on pages 19 and 20 to address a supervisor's access to respondents' animal patient records, and that a supervisor may evaluate all aspects of a respondent's practice. The amended language would also clarify that a supervisor must be physically present full-time when respondent provides treatment or consultation to an animal patient during the first quarter of a respondent's probation, and quantifies the accepted levels of supervision that may be imposed thereafter. This change is proposed in response to Ms. Lutz's recommendation. So again, anything in double underline blue or double strike through red is in response to her recommendation here. But for this item here, this sentence, for the first quarter of the probationary term, the supervisor shall be physically present with a respondent on a full-time basis while respondent provides treatment or consultation to the animal patient. And Jessica, maybe we have 2 options here for you to further define physically present. So what you see here in yellow highlight is proposed or potential additional language that could be added to this sentence in order to provide a better definition of what physically present means. So,
Yeah, so I'll just jump in real quick, and I have to really thank Ginger, our probation monitor, and also Matt, our enforcement manager over probation, for providing some guidance and some clarification of where probationers tend to get a little confused on this. Even if it says physically present, what does that mean? Is it physically present in the location because they are still with the respondent at the location? Does it mean they have to be in the room observing the services? And that's really up to the board to decide. I think one thing to keep in mind, though, is if we define it to require them to be physically present to be able and in the room, it might be one thing if the probationer owns the clinic and has the money to afford another veterinarian in the room to supervise the services, but it's another thing when you have a probationer who is employed by someone and requiring that a veterinarian provide the direct supervision or the immediate supervision when they're in the room. It could get costly, and it begs the question of why an employer would want to pay for 2 veterinarians when they're just getting one patient getting the services. So, but this is I think a clarification that we need from the board of what they would like to see and what the board thinks of when they're adding this requirement for the physical presence. So the 2 options would be the first option is requiring them to be present in the room, and like it says, this would be it would start out at 100% full time and then could be modified after a certain portion of their term. But the second option it more directly aligns with the definition of direct supervision when it comes to the RVTs and the VACSPs. And that is that they're quickly and easily available at the location.
Justin, are you done with your presentation?
I have 2 more items. Yeah, I wasn't sure if did we want to make a decision on this item at this point or when we do the motion?
Finish your presentation and then we'll make it.
We'll circle back.
Yeah.
Okay, sounds good. Okay, so item number 8 refers to the medical records review section here. And I'm just reading from page 5 of the memo. Add language under optional term number 7, medical records review, on page 20 to clarify that if a respondent's terms of probation include supervised practice, that supervisor may also serve as the medical records reviewer. And again, this change is proposed in response to Ms. Lutz's recommendation. And then finally, on page 21, item 9 on page 5 of the memo, amend language under optional term number 9, no management, on page 21 to clarify that a respondent shall not function as the responsible licensee manager for any veterinary hospital for the duration of respondent's probation, and cite to BPC section 4853 subdivision C, which defines responsible licensee manager. This change, again, is proposed in response to Ms. Lutz's recommendation. So that's essentially it. There were some other minor or technical revisions that you may have seen in here, non-substantive minor changes. So those are the proposed modifications. And then I'll turn it back to you, Dr. Nunez, to see if there is additional discussion. And I do have some new motion language. Once we get to that point, we kind of fine-tuned the motion language. So once we get to that point, I will pull up that page.
Yeah, that motion language is my favorite part. So I was looking to see when this all started, and I referred to the chart. It started in January 20th, 2015. So 6 years we've been working on this. But we're close. This as Justin just summarized, was after a 15-day public hearing period, and all the responses were listened to, and some of them were accepted, some of them were not. And I think there was a total of 14 when you add the initial 4 and the last 10. And I think that they're, rather than going through all 14 of them, I think if there's any specific questions from the board members on that, there's one of the items that needs input from us, and that's the one that's related to what does it mean when they are directly, there it is. Does the supervisor need to be physically present or kind of within the hospital or something like that? Quickly and available at the location. So are there, with the exception of that one item, are there any questions or comments about the other 13 items on this list that Justin just presented? If you would like my opinion, I am perfectly fine with the proposed responses. We have Dr. Bradbury.
Hi, Justin, thank you very much. This is great, and I do feel like we're almost there with all of these. On the management one, the management point, I just want to make sure we're all okay with I guess I didn't realize that our intention was that it was just that they couldn't function as the responsible licensee manager. I thought that, I guess I wasn't wanting them to necessarily be in like the manager of the hospital. They don't have to be a licensee manager, but if they're managing the hospital, maybe that's not the best idea either. So I just wanted to make sure everybody agreed that that's the only type of manager that, or the only type of management that we want them to be excluded from. So that's my only comment. Otherwise, I'm good with that, and I'm happy to comment on the other part as well, but that's my comment for now.
So your concern is that even though a probationer is not the responsible licensee manager, you would want additional language to state that they can't function in any other sort of managerial role? Is that what your concern is?
I guess I didn't realize that that was our intent in the first place. And so this is, I guess it's now been very clearly defined, and now I understand it. I just want to make sure we all are comfortable with that being the only exclusion from management that we want. I think this has actually come up in some of our we've been reviewing cases and things where people have acted as a manager but weren't the licensee manager, and we were wondering if that was a violation of probation, and I think this would help clarify that. And I'm fine with this. I just want to make sure everybody else is as well.
And I just want to clarify too that we're not saying that that was the intent, and because we obviously weren't here around that time, and I think that's a genuine concern. And you might want to consider making it so they shall not manage or function as the responsible licensing manager. That's also another option, because when you say that, I actually think that could be a concern, because we see a number of probationers who are no longer technically the MGL, but they are clearly still managing the office and doing some things that might be concerning.
Yeah. What was the reasoning to cross out administration? Your name might not technically be on record as being the licensing manager, but doesn't mean you're still not the person in charge, the person that calls the shots in how a practice is run. So what adding the term function, what did you suggest, Jessica?
So to address the concern that Dr. Bradbury raised, you could just change to respondent shall not manage or function as a responsible licensing manager for, and then continue on. So it makes it clear that we mean both. We don't want you managing the office, and we don't want you functioning as a managing licensee.
Would that be clear enough and defensible enough?
Well, Tara's raising her hand, so you might want to call on her.
Okay. Tara.
This is Tara. I just wanted to point out that some of our respondents are RVTs, and they may serve in management roles at a premises, but could not possibly be a responsible licensing manager because they're not a licensed veterinarian. So I think that we should address this issue to ensure that RVTs who otherwise hold a management position but have demonstrated concern because they've violated the Practice Act, we should open this up a bit more to cover those instances, not just veterinarians who have violated the Practice Act. So I think that we could make Jessica's recommended change to limit this term to prohibit the respondent from managing or functioning as the responsible licensee manager. And then I think we would probably need to follow that up with the probation monitor's instructions and discussion with the respondent to especially inform RVT probationers that this term means they cannot serve as a manager at the premises, just to highlight that piece of it so they're aware that it applies to them.
Do we have to then I mean, I think part of the problem here, right, is that it wasn't that well defined. So do we need to define what a manager is? Is it just being like in a leadership position overseeing any other employees, or like, I guess that's the concern, right? Is that there's not a clear definition here.
I think that the concern was more as if whether we mean a manager of the office or the MGL. And so I don't think here is a concern. I don't think we need to define manage or and define what services they're providing. I think that it's clear enough as long as we just do this shall not manage or function as the responsible licensing manager.
Would that be a non-substantive change, or would it have to go back through a 10-day hearing period? Not that it matters, but.
Well, with all of the amendments that we're proposing, we would have to go back for a 15-day public comment period anyway. So it is going to be out there after the board approves this.
Yeah, okay. I would, I'd be okay with adding or, and then when we get to public comments, that issue might be brought up again. Dr. Nolan?
Yeah, my comment on that would be, would instead of saying or, you could say including being the responsible licensing manager. So, because they don't exclude each other. Anyway, but that's not why I raised my hand. So I want us to finish this conversation first and have other comments, because I had another issue.
Do any of the raised hands have any comments on this no management issue? Do any of the Kathy?
This is Kathy. Actually, I'm glad Christina brought it up, because that was going to be my question too. I like broadening this because I think the intent was not manage. If you're a probationer, should not be managing, and just being the MGL is one thing, but you could do many other managerial approaches in a clinic. And so probably Jessica's language may be a little bit better. So that was my point on that one.
So if there's no other comments on management, Dr. Nolan, if you wanted to continue.
I have a comment. This is
Tara?
Tara.
Okay.
So in going back to the reason why we're even making this change, I was looking at Ms. Lutz's letter, and she recommended the change because over the years she's had numerous veterinarians on probation question the provision, which currently says respondent shall not manage. And she believed it's best if it's clarified. I think if we did shall not manage or function, would continue to serve the purpose in clarifying the provision as recommended by Ms. Lutz, as well as incorporate additional types of respondents such as managing RVTs.
Very good. If there's not any other comments from board members on management, then Dr. Nolan can continue.
Okay, thank you. I think, again, we've been talking about this for a long time, so maybe I'm confused, but if I could get clarification, I am on page 19 where we're talking about supervision, and we are trying to get away from direct and indirect. Is that correct? Is that my understanding?
So we're trying to clarify what supervision means, because in the past, the direct and indirect didn't match the current regulations of the definitions for direct and indirect, and the indirect before really meant the medical record review, and so that's why we had separated it out. So now there's no direct indirect, it's supervision, which is defined, and there's medical records review. So it's a lot more clear to the probationer and to the monitor what is expected out of this condition.
Okay, thank you very much for that clarification. So then I would like to just make the point that I believe we have seen cases over the years that do not require the first quarter probationary term to be 100% supervised. And I think that becomes punitive in some of the cases that we have actually dealt with. And so I'm not really comfortable, at least personally, with having to do 100% full-time with every case if they need supervision. So that's, I don't know how everyone else feels, but I do think we have had cases that in which that would be viewed as almost punitive instead of reformatory. And feel free to tell me I'm all wet. I'm And is anyone talking or am I supposed to keep talking?
I was talking, but I didn't undo my mute button.
Oh, thank you. Okay, thank you. I got a little nervous.
Yeah. These are respondents that have been gone through their due process, and the decision was made and approved by the board that they require direct supervision. In those cases where you think that they don't require 100% supervision, then would they have been given that term in the first place?
I think we need the options, Mark. I think we're really boxing ourselves into a hole here and saying we either have 100% supervision for the first quarter of the probationary term or medical review, medical record review. And I think that that gives us less flexibility, and I don't feel like that serves our consumer mandate as well as it could.
Just to clarify, it's not doing full-time 100% or medical record review. This is its own separate condition, separate from the medical record review,
Right.
requiring the supervision of the supervisor and what that looks like. So how it's written now is that it would have the full-time basis for the first quarter, I believe, and then it would go down. It could go down to the substantial, moderate, partial throughout the rest of the term of probation. So it wouldn't be 100% full-time the entire time.
But in the past, we've been able to start with a substantial or start with moderate. We've had options in the past, and this removes our options to some extent.
Would it be possible, similar to the way that a respondent is ordered to take drug testing, they do have the ability to determine the frequency of it without us telling them, because they may be a little bit more qualified for that? Would it be possible if direct supervision is determined to be a term of probation for the probation monitor to decide if it needs to be 100% or any other level, or no? Do you think that wouldn't be reasonable?
Yeah, that would be something that you could amend here to basically how it was before. It left it up to the probation monitor to decide the appropriate level of supervision. It just doesn't. I think that the concern with that is they don't always know what the board is requesting. So if the board felt it was 100% supervision, but it's up to the probation monitor, they might do less or they might do more. And so I think that's the concern, is that we don't know where to start.
I see. I think that the proposal that Dr. Nolan is saying is to lift that requirement that the first quarter needs to be 100% and give either the probation monitor or the board to determine if we really do want it 100%, we can do it. But if we don't find it necessary, it doesn't have to be done. And with that, yeah. Any other?
Sarah, I've got a proposed way to revise this language to get at what you're talking about. I don't know if you want to see this or if Justin can make these revisions on the screen or not. Justin, are you available to type in?
Yeah, I can pull it up here.
Go for it, Tara. And I do see Kathy Bowler's hand up and Dr. Bradbury's hand up as well. So I'm not ignoring you. Oh, Dr. Bradbury just lowered her hand. So Kathy, I see you.
Okay, Tara, I'm ready when you are.
Okay, so I don't see the document. Oh, here we go. Okay, so that, oops, it vanished.
Oh, you're not seeing it?
Okay, it's back.
No, I think we're looking at the PDF, but Justin, we're not seeing the Word doc if you had pulled that up.
Okay,
Yeah,
gotcha.
it just goes to a gray screen though, so we are not seeing what you're typing.
Okay. Hold on.
So Justin, are you sharing your screen or are you sharing an application?
I guess I'm sharing an application, so what do I need to do here?
In order to scribe on it, you'll have to share your screen.
Okay,
So
here we
make sure
go.
you have the document open on your screen first and then share your screen.
Okay, I think I switched over. And
That worked, thank you.
okay.
So,
Okay, we can.
All right, so the beginning of the paragraph is for the first quarter. Let's go first to the second sentence. It says the level of supervised practice. And let's revise this first. And to say the level of supervised practice shall be, comma, as required by the board or its designee, colon, and then it would go to levels of supervised practice, and then cut may be modified as determined necessary. We'll make that a new sentence after the levels of supervised practice.
Okay, so I'm striking all this here, right?
Yeah, cut may be modified through the rest of the sentence. Cut that, drop to the next page. Right there, insert, copy.
Oh,
And we'll,
I'm sorry. So I'm copying this part here?
yeah.
Okay.
I can also just read it off if you just want to type it.
Okay, let's do that. I'm struggling here. Okay, so
Okay. So, so here we'll have a new sentence that says the level of supervised practice.
hold on. Why is it doing that? Sorry. Bear with me, Tara.
Actually, can you go down the page? This sentence actually exists right there. The level in red, it says the level of supervised practice may be modified. Let's unstrike that.
Okay.
We can just leave that whole sentence in, and that authorizes the probation officer to lower the level of supervised practice later.
Okay.
So it's up there right by where you can bold it and italicize it. There's an A and a B with a strike through. That's what you need. Yeah, there you go.
Yeah.
You get by with a little help from your friends.
So then we'll go back up to the prior page.
I'm just going to highlight that for now to know that it comes back. Okay.
So now let's strike for the first quarter bit. Actually, I think that's, yeah, I think we can just, what we need to do is, so strike for the first quarter, the probationary term, strike that. And then, because we still need to explain what is, how often the supervisor needs to be there or how they're present with the respondent.
Yes.
So here we can, I don't know what you guys picked. I think potentially, you know, we could go with RVT and or VA supervision, direct supervision, which is that quickly and easily available. I don't know, you know, is it necessary to have them physically present in the room with the respondent?
So,
I don't know. I'm asking you guys.
so before you make any additional changes, should we discuss those two options?
Yes.
Okay. So, Kathy, would you like to say something at this point?
Hi. Actually, we're so in the weeds here. I don't think, what I was going to ask way back when was, did we want to, does the staff need a approval for the proposed responses? Well, maybe now we're modifying these proposed responses. So, never mind.
Okay.
Forget I raised my hand. Bye-bye.
Okay. So then the question now before us, board members, is what does direct supervision mean? Does that mean that the supervisor needs to be physically present in the room, or can the supervisor be quickly and easily available at the location? And Dr. Nolan's hand is up.
I think that especially in the clinics I've been in, there may not be room for another person physically in the exam room. I think that having them quickly and easily available is preferable.
Who is going to call that person into the room if they are quickly available? I mean, if the role of the supervisor is to ensure that the probationer is practicing as should be.
Yeah, but I think that the idea of direct supervision was to, and we were trying to eliminate the loophole of a direct supervisor who wasn't on premises. You remember there were people that were getting away with that, and that I think that the idea of having them exactly in the room with them at all times wasn't the goal. The goal was to have them at least present on the premises, and that's kind of the same premise we use for direct supervision of other things in our regulations.
So saying when a VA is under direct supervision of an RVT, they have to, you're saying that they have to be within the vicinity, not in the room.
Right, they have to be on premises. In other words, they have to be readily and easily available. I don't think that terminology is any different than what we use for direct supervision for RVTs.
That's true. This is Tara, but I guess what we need to recognize is that in a typical direct supervision of an RVT or VA, neither one of those individuals has demonstrated a problem with their care of animal patients.
Mm-hmm.
Such, you know, which is what we're talking about right now. We know if we're assigning supervised practice as a term of probation, there's something wrong. So I can see the probationer not quickly calling out to the supervisor to say, hey, I'm having a problem here. Why would they do that? If this is a veterinarian, they're just going to diagnose and treat the animal patient, and the supervisor may or may not know that there's a problem, that they should have been physically present at that time. So I could see it being a problem in that the supervisor is on the premises, but the probationer is continuing their bad practices on animal patients.
Well, so if this probationer is that unstable or unsuitable that a person has to be physically present in the room, we probably should just revoke their license, because I can't imagine anybody tolerating, like I think was said earlier, how you're going to pay 2 veterinarians, or you're going to have 2 veterinarians treating one patient for months at a time. It doesn't even make, I mean, I don't see how that's going to be really very possible.
Again, and if it is, we've removed the mandate that it has to be 100%. So if I think that we have flexibility from the board or the staff, I do think that there could be some instances where the person has shown evidence of rehabilitation, but there are some extra concerns we just want to make sure, and not just have the option, and not just have to default to pulling the license. And I don't think that there's a fair comparison between how a DVM or an RVT is directly supervising another person that they have already determined is qualified to do the task, when compared to somebody that we know has already violated the Practice Act and has been disciplined for it. And
Well,
they're not going to call in the supervisor and saying, "Hey, I'm doing it again."
I think they will. Well, but I think if the board has determined that they are deserving of probation, then I do think that they will be amenable to that, and that would be a viable opportunity for them to be rehabilitated. This is not a punitive, board. This board is to protect consumer, to protect the consumer. If we think that a probationer has to have another veterinarian in the room at all times, then that's a problem in my mind. I think we're trying to help rehabilitate them. We feel like they can, with a probationary support system, become a better and a acceptable practitioner. So I think it's punitive, and I think that I guess I just don't agree. I think having them quickly and easily available, it benefits the probationer, because they are trying to, I think, become a better practitioner. They want to get better. I mean, we're assuming that they do. If we don't think they have that ability or that desire, then we shouldn't be giving them a license even under probation.
Tara?
So I'm looking at another board's supervised practice term. This is the dental board, and their term says the plan of supervision shall be, and this is an option, direct and require the physical presence of the supervising dentist in the dental office during the time dental procedures are performed. And a second option is general and not require the physical presence of the supervising dentist during the time dental procedures are performed, but does require an occasional random check of the work performed on the patient, as well as quarterly monitoring visits at the office or place of practice. My point here is that this doesn't even require the individual to be physically present while the patient is being treated, but it requires the supervising dentist to be effectively, for our purposes, at the premises.
So your example would be more towards option 2.
Correct. And potentially with an occasional random check of the work performed on the patient. That might be a helpful item to add.
Okay. Well, I think that Dr. Nolan has made some good points in support of option 2, and I've made some good points in support of option 1. Do any other board members have some thoughts to help us with this issue? Kathy?
Yeah, I'm kind of going back and forth here. I understand both points of view. I sort of like Tara's combined option with the random checks, or however, added to option 2, to give a little bit more supervision rather than, counting on the probationer to request another veterinarian to come in and check things out. Just having random checks by the supervisor might give some additional protections.
So that proposal would be that the supervisor is quickly and readily available, but he or she has the option to randomly pop in and make sure that things are going well.
Right. However, the dental board language kind of was written, maybe modify using some of that.
And the frequency of these random pop-ins will be determined by the supervisor.
Maybe Tara could read that again. Tara?
I'm trying to type up some language for your consideration. I think rereading theirs isn't quite what you need, but I'm looking at something like the supervisor shall be physically present and quickly and easily available at the location. The supervision shall require an occasional random check of the work performed on the animal patient.
I like that. I would support that.
Tara, this is the moderator. Would it help if I open the chat so that you could send that typed language directly to Justin through WebEx?
I can email them.
Okay.
That's actually what I'm doing. Typing it into an email.
Is there anyone else on the board that has other, that would like to give other options or, have other ideas?
I was thinking, would it be, is Bonnie listening in? And I know it's a bit unconventional, but if she is in, I was wondering if we could open up Q&A and maybe hear some thoughts.
I'm the newbie here, but I'm gonna just jump in real quick. In the teaching world, if you're in trouble or if you're on, one of the first year probationary, we ask for random observation by the principal. So the principal pick at any time and pop into the classroom and do an observation, 5-10 minutes, depending on what they think. So.
Is there any definition of what that random is, like 5 times a week or nothing like that?
In our case, it just depends on the availability of the principal, because it's, if they're available, sometimes they just go and randomly pop into classrooms to make observations. And it depends on their availability, or depends on what's going on in the classroom. If the kids are hanging off the chandelier, maybe they would stay longer. And if they go in and all your ducks are in a row and you're doing what you're supposed to do, then they leave. So that time, that observation period is depending on what they observe, I think.
Now, how many public schools have chandeliers?
Good one.
On line 3 of, I think actually it's 4, it says occasional random check of the work performed. Maybe instead of check, we could say occasional random observation of the work performed.
Dr. Nolan, are you okay with that?
Yeah, I think it's a great compromise kind of from, our two positions, honestly.
So, Justin, we would want to strike, that all the way, that whole first sentence would come out. So it would just begin, The supervisor shall be physically present and quickly and easily available at the location. The supervision shall require an occasional random observation of the work performed on the animal patient. The level of supervised practice shall be as required by the board or its designee with the levels of supervised practice. And then that final sentence that says the level of supervision may be modified as determined necessary. Jessica, do you have any concerns with this language?
I don't. I actually really appreciate it. So thank you for the discussion and making it more clear.
It's I see different colors, but it's written down on the screen what we've decided, because it starts with the supervisor shall be physically present and quickly and easily available at the location. The supervision shall, yeah, that's all.
My
Yeah,
only
so somebody
concern now
clarify.
is that second provision there, the supervision shall require an occasional random observation of the work performed on the animal patient. We don't necessarily want every single animal patient to have a random observation where the supervisor's popping in. So should we change that to occasional random observation of the work performed on animal patients?
I think that's what I see. That's what's written.
I think this is too limited on the animal patient. I think we need to make it more general, so it's just animal patients in general, not every animal or the animal.
Well, and you know what, Tara? I think you could actually leave off the animal patient, because some of the work is actually record keeping, and some of the work is,
Yeah.
you know, so it actually would be good to, depending on what they need to supervise, to leave it just the work performed.
Yeah,
Or
I
work
was
performed by the respondent or something. Yeah, that's what I was thinking.
I just ended work perform, I think.
I think by respondent is appropriate, because we need to make sure that we've got the supervisor and the respondent separated here. So the supervision of the work performed by respondent, I think that works. And Justin, will you capitalize that respondent?
Yep, got it.
I mean, this is the disciplinary order to the respondent, so I would assume that the supervisor is supervising the respondent and no one else. But I won't be offended if we keep it in. And then, are there any other comments from board members? Because I would love to hear from the public.
Justin, can you delete, there's a capital Y right before the levels of supervised practice. Can you just delete that? Thank you.
Got it. Mhm.
And it's Kathy, can I clarify, the beginning of the sentence is the supervisor up on top?
Yes.
Okay, so should we capitalize T?
It is capitalized.
Oh, and I can't see it with all the colors. Sorry, it doesn't look like it's capitalized. So that's
Yeah.
the beginning of that sentence.
Justin,
Yeah, that
can you
was-
change the font color so that it's all the new stuff is blue, so it's a little
Yeah.
easier to read?
That's
Yes.
a good idea. I was looking at the supervisors. Sorry.
Yeah, that's what I said. There's lots of colors and lines here.
Mark, do you want me to make a motion about this before we open it for discussion, or would you like to wait?
Well, I think that there was only, are we going to just accept everything, or do we want to accept this one individually, because there's lots of proposed responses and changes. I think if we can finish this, we can vote on the whole thing.
I had a question. Did we want to address the no management term? You know, we had talked about adding manage or function.
We did already, and I think
Okay.
the conclusion was to add or.
Okay.
So when we vote, that would include that change as well.
Okay.
So you
Right, so
Okay,
we're actually replacing manage. So shall not manage becomes, manage just goes back to black, straight text.
Okay.
And then after manage will be the word or in blue double underline.
although we could go with function or function. That might be an option.
Try it, Mark. And blue and red too.
Okay, I'm sorry. I'm just going to write. Okay, shall not manage or function.
Right. And then get rid of, yeah. I can only
Okay.
imagine the pressure you're under, Justin, but
No, I'll clean this up.
okay. So we made a change here, and then we made a change down below, and the staff made lots of other changes. And do any board members have any other comments on the entire disciplinary guideline? If not, then I'd like to open up for public comment.
I will leave the language up there and trust that our public.
Do we want to have a motion before going to public comment? Because otherwise you're going to have to do the motion and open it up again.
Darn it, you're right.
I would like to motion that we accept the changes just made to the disciplinary guidelines, and both the changes made by our staff and the two changes we just made. We'll just keep that separate, Mark, from the actual responses. Or can we do the responses and can we do the modified text together, or we have to do them separate?
I think we can do them together.
Okay, I would like to.
This is Tara. The motion that we would like is on page 5.
Oh yeah, it's the new language.
Yeah, the meeting materials.
You know what, Tara? Yeah, we reworked the motions a bit. Can you see what's on my screen now?
I can, and I was going for the second one, and then you threw up the proposed responses also. So I was thinking we're just working on the modified text. So
Right.
can I make a motion to approve the proposed second modified text that with the amendments that we have made just now for a 15-day comment period? And if there are no adverse comments regarding the specific adoption, amendment, or repeal proposed in the second modified text received during the 15-day public comment period, delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file and adopt the second modified text as modified today.
I'll second.
It's been motioned and seconded. And hearing nothing from Tara, I think that we're doing it correctly. Are there any other comments from the board?
I am happy to make the second motion as well and then open it to public comment if that's allowable.
Is it allowable, Tara?
Yeah, that would be fine. I mean, they both work together, so that way you're kind of using your time wisely.
Okay, then I would like to go ahead and propose to us to approve the proposed responses to the written comment with recommendations received during the 15-day public comment period and direct staff to incorporate the responses into the FSR when proceeding with the final rulemaking package.
I second that.
We have two motions that have been which have been motioned and seconded.
This is Tara. I didn't catch who made the second on the second motion.
Judy Key.
Yeah.
Thank you.
Who still hasn't told me how many chandeliers are in public schools, but we don't get that information right now. Any further discussion from the board? Very good. Moderator, could you open it up to the public?
Yes, would you like me to leave up Justin's display, or are you good for me to take that down? I can do it either way.
I think you can take it down.
Okay. All right, so with that, we've opened the Q&A panel. If you'd like to make a comment on this proposed regulatory package, please click on the Q&A icon on your screen, type comment, or I would like to make a comment into the text box, and submit that to all panelists. All right, and I am not seeing any requests for comment. Would you like me to close the panel?
Yes, please. Amazing. Amazing. It's been motioned and seconded. Members of the public have been given the opportunity to comment. If there are no further questions from the board, call for the vote.
Okay, so to clarify, we have two motions and you'll be voting on both of them. So the first, I'm going to take them at the same time. So Ms. Bowler?
Yes and yes.
Dr. Bradbury?
Yes and yes.
Ms. Key?
Yes on both.
Ms. Laredo?
Yes and yes.
Ms. Prado?
Yes and yes.
Dr. Solicito?
Yes on both.
Dr. Noland?
Yes and yes.
Dr. Nunez?
I'm going to say double yes.
Motion's carry.
Next item. Drug company.
Yes, sir. And that will, item 9C will be presented by Karen Halbo.
Karen, I think you're muted.
Thank you. I pushed the button and it didn't. And I think the video is not doing what it should do. So I'm just going to give you the verbal. You have the memo. The final package was submitted to legal for the various reviews with the director and agency, and concerns were raised about clarity in the text, and there are some pretty simple fixes that could be done by a 15-day to resolve those clarity concerns. Mostly it's adding sterile or non-sterile. You can see the memo walked through the changes for section 2091A. It's adding the phrase through reliance on drug compounding standards in the profession and in accordance with section 2032 to clarify how a veterinarian will ensure the safety and efficacy of a compounded drug preparation. For 2091B, adding sterile or non-sterile, and also for 2091C. And for 2093C, upon trying to really look at this and justify allowing a veterinarian to expend an expiration date of a compounded preparation beyond the limits that are already imposed in subsection A and B, it was determined it would be better to simply delete the subsection C, and so it was deleted. You might note in the memo it says at this time, the board with different constituent elements might decide to change this in the future, and we have nothing saying that that can't happen. It's just right now with the drugs compounding that are available, this is not necessary or in the protection of consumers to allow a veterinarian to extend the expiration date. On section 2095C, it was decided to replace as soon as possible, which OAL has determined is vague and needs more specificity, with the term immediately. So the common practice is once you've figured out your medication that you've sent out is not what it should be, is to immediately contact those people who have the medication. And on section 2095D, this was somewhat more complicated. Essentially, we were trying to exempt from discovery some of the quality assurance records as peer review documents. And this appears to be beyond the board's authority. The memo goes into the weeds on that, explaining what it is. And it is simply that the Veterinary Medicine Practice Act doesn't have a statute that would give the vet board the authority to protect those records from discovery. And in a future meeting, you might consider requesting getting legislation like that, which the pharmacy board does have, but the veterinary med practice doesn't give that. And to move forward with this package, it was seen as a good idea to simply strike that portion of the text. So I would ask, Justin, do you have the motion language for this motion so that when it gets around to making a motion, the board also has that language in front of them to be able to do the motion properly?
Yes, I have it here, and I can pull that up for you, Karen.
Thank you. After your stellar work with the previous job, thank you very much. So are there any questions from the board? Oh, and I just want to remind you, on a 15-day, the only things the public can comment on are the changes that are the subject of the 15-day. So we are not reopening up all of the drug compounding language, only these portions to which the changes are made.
Does anyone know what the reason was that the expiration date may be extended if the product's integrity, potency, and quality are measurable and demonstratable was there in the first place?
I'm no help. That discussion predated me.
I don't recall why it was there. It
Knows, but-
I think it would be difficult to be measurable and demonstratable, so I'm not opposed to it, but I wonder why it was there in the first place. And I completely understand the reasoning behind the board not having the qualifications to consider peer-reviewed documents in the field of pharmacology. It would, I mean, we definitely have pharmacists in our profession. But it might be difficult to abide by that. So I understand it. And it is always difficult to achieve a state of clarity when these are going through. I was especially confused of why there was 2 page numbers at the end of the document, but then I figured it out. It's the bottom is a continuation of the entire document. Any, okay, board, what do you think?
Mark, I put my hand up, but I just had a quick veterinarian question. I agree with all of these changes that or that legal folks have requested. I just had a question, knowing how long regulations take, was that if there was a time when expiration date could be extended, which you brought it up, if it was demonstrable that the potency and quality were still in effect. If we wanted to put this back in for some reason, it would be a long process to do that, correct? I'm asking probably Karen, I guess, and Justin, and it doesn't seem like there's any need to have it in anyway, but I just had that question while we're removing it.
Well, I'm willing to make the argument that the regulations process should be getting faster. And I know that these have been around a long time and that there's a lot more to go. But I think that the concern that any regulation will take 3 years is no longer completely realistic. The regulations unit has worked hard to standardize the review process, and we have had 57 different packages go last year to OAL, and none of them have been declined. So the quality has gone up, and I think that you have really good people. So I guess I would say, I know that in the past things have taken a very long time, but it's certainly my job to make things go faster and to try to assist Justin in making things go faster. So I don't think that this is a dead end to ever be able to change this. It's just right now, there doesn't seem to be a compelling need to. And going forward, I can give you my word, I'm trying to make it go faster.
Okay, got it. Thanks.
I don't see any other hands. But does anyone have a motion?
I can make the motion that's in our packet if that's still the same text.
Moderator, if I could show my screen again, we did make a few tweaks to the motion, so I'll pull that up for you.
Okay, thanks, Justin.
Mm-hmm.
And if I can explain, motion tweaks are going to improve the getting through the review process. We don't find out down the road, ooh, we're missing this one word. It's amazing, but the difference between the board approving and the board adopting has large legal consequences. So hence, we're really looking at our motion language.
Okay. So it's the second, it's that block. Okay. So I would move to approve the proposed second modified text for a 15-day public comment period. And if there is no adverse comments regarding the specific adoption, amendment, or repeal proposed in the second modified text received in that 15-day comment period, designate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file, and adopt the second modified text as modified. Let's say modified 12 more times.
Can I ask you to revise that? You use the term designate to the executive officer, and legally that does not give her the authority we need.
I'm sorry, I meant delegate. It says delegate. I read designate, it says delegate. I apologize.
My
Delegate.
my God.
God, what a mistake. Yay.
So
I
I would,
would arrest myself right now. I'm sorry.
this is Jamie. I'd like to second the motion.
All right, it has been motioned and seconded. If there are no further questions from the board, we can open it up for public comment.
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on this item, please click on the Q&A icon on your screen, type comment into the text field, and submit that to all panelists. And I am not seeing any comments. Would you like me to close the panel?
Yes, please.
It is closed.
Been motioned and second. The members of the public have been given an option to comment. If there are no further questions from the board, call for the vote, please.
Ms. Bowler,
Aye.
Dr. Bradbury,
Yes.
Ms. Key,
Yes.
Ms. Laredo,
Yes.
Ms. Prado,
Yes.
Dr. Solocito,
Yes.
Dr. Noland,
Yes.
Dr. Nunez.
Yes.
Motion carries.
So I know that there was a request to move on to agenda items for tomorrow, but typically if this is posted and there's members of the public that want to talk about a certain issue, if we talk about them today when we said we were going to do it tomorrow, then that might be a problem. So it is it's 2:46 and we've completed today's agenda, so I'm going to recess until tomorrow. Thank you everyone for your participation. I think that we have the best board in all of the country.
Thank you, Mark. Thank you, everyone.
All right, see you tomorrow.
Bye.
Thank you.
Bye.
Bye.
Bye. Thank you.